Is there any chance I'm really going to be sued for breaching my employment contract with my employer? I'm Erin Jackson with Jackson LLP Healthcare Lawyers. We hear this question a lot, and the answer is usually either yes or it depends. Rarely is the answer no. So an employment contract, even in an at-will employment state, is generally a binding contract. That means that in this contract, both sides, the employer and the employee, have exchanged promises. Now, if one side doesn't uphold their promise, that's considered a breach of contract. So an employee leaving before the employment contract term is over, or violating the non-competition or non-solicitation clause, or not upholding performance standards or some other type of metric required by the employment contract, could all be considered breaches of the contract. So in response to an employee breaching that contract, it is not uncommon for an employer to pursue that employee for repayment of a relocation or retention bonus, for the cost, especially amidst today's hiring shortages and staffing shortages. We've seen situations where the employers are seeking compensation from the employee to cover the cost of hiring a replacement person to fill that position. Especially for highly skilled positions, this can be extraordinarily expensive and easily be in the five-figure category. Now, there are also situations where the employee is potentially breaching the non-competition or non-solicitation clause in their contract. In these situations, they might end up at a higher risk of getting sued because the legal mechanism for pursuing them, called a TRO, or a temporary restraining order, is intended to say, hey court, we've got an emergency, you have to stop this person from doing what they're going to do because they're going to cause irreversible damage to my business. So the long and short of it is that yes, it is possible that your employer will sue you for breaching the contract because they're going to suffer financial consequences by your departure. Now, that doesn't mean that there aren't defenses to such a lawsuit, and it also doesn't mean that you're stuck with that employer until your contract is over. It just means that it's best to have an attorney review your contract and walk you through the departure from your employer rather than going it alone. There are also situations where you may be considered to have been terminated under this concept called constructive termination, which means, yeah, I'm leaving, but I'm not doing so voluntarily. Essentially, by either harassing me at work or failing to accommodate a disability, you have constructively terminated me because you've made it impossible for me to do my job. So in these situations and many others, we can help negotiate your departure with your employer and hopefully minimize the chances of you being sued and minimize the financial cost of your departure. Feel free to reach out for a complimentary consultation to discuss your contract and the next steps for your career. For more tips on staying compliant, subscribe to our YouTube channel.